So today we shall discuss about the role of AI, that is artificial intelligence in cybersecurity, because it can be a threat, it can also act as a defense. Like any tool, it can be used, misused, or abused. So we shall see whether AI and how it affects the legal profession to us like law students and practicing lawyers. So in this session, we shall see about the both things, that is threats as well as defenses. Firstly, we shall see that is navigating legal challenges in the Indian digital ecosystem. So what are the challenges that are posed by the use of the AI? So this presentation is especially targeted to the LLB students and say practicing advocates rather than the technology professionals to whom I generally teach. It will take about 60 minutes or more, and we shall start. I am giving the detailed contents of this. Today's agenda is India's journey, today's journey through AI and cybersecurity law in India. So specifically, we shall see what are the Indian law and how they compare with the Western laws. These affect to cyber crimes, also to the privacy laws. And now the third thing that is coming is the AI law. So we don't have dedicated AI law at present, but the Information Technology Act 2000 is under review, and the Digital India Act is likely to come into effect anytime once it is drafted by the MeitY, that is Ministry of Electronics and Information Technology. So this presentation is divided into 5 parts. First, we shall see the introduction, that is the AI revolution, how it is changing the Indian cybersecurity scene. Then we shall see in the first part the AI as cyber defense, that is the positive aspects of AI, because for maintaining cyber security, now artificial intelligence is being used and it can be used as a great defense. So legal implications under Indian law. In the second part of presentation, we shall see AI as cyber threat, that is the disadvantages. Now there are say AI through which the images can be changed, cartoons can be created, deep fake videos can be there. So AI is also becoming a cyber threat because it's a tool, and as I told, it can be used, misused, or abused. So what are the Indian legal challenges? So we shall see the present law as well as the forthcoming laws. In part 3 of this presentation, we shall see the Indian regulatory landscape, various regulatory bodies like SEBI, RBI, IRDAI, MeitY, and we shall see what is their role. So these different regulatory landscape and compliance, that is what is the compliance or say due diligence say precautions that they have to take, which we can say advise to our clients or the companies. Then the liability under Indian law, we shall see the civil as well as criminal liability and how different laws affect, and what is the role of say contract law or maybe say consumer protection law or advocates act, how it affects us. So we shall see this present Indian law and how it affects, because there is say AI as well as computerization of judiciary itself, and the attribution issues, that is how the legal actions, how the different actions that are done on computers or internet can be attributed, that is accountability. Okay, जवाबदेही सुनिश्चित करना, निर्धारित करना. So that we shall see how we can attribute these things. And future legal considerations for India, that is what are the forthcoming laws or what are the deficiencies in the present laws, that we shall see. First, opening question. So I'm presenting a scenario before you. So consider the Indian scenario, that is there is say a Mumbai based law firm and it is AI powered say security system is there. Advocates are also using it, and there are say some, it automatically blocks because there could be some threat, and it automatically blocks what is say it appears to it as a cyber attack. It's an attack on availability. There are 3 things in cyber security: confidentiality, integrity, availability. And to prevent the attack, it suddenly blocks. Because of that, advocates may fail, like inadvertently it is preventing a client from accessing say critical systems before a high court hearing. That means the advocate or the clients are not able to approach and view say video conferencing or maybe present their case before the honorable judiciary. So this type of scenario could arise. A security question. Now the legal questions that arise in such scenario, that is what liability under the Indian Contract Act 1872. So there could be some contractual obligations. Secondly, does the Consumer Protection Act 2019 apply? Because there are advocates, there are service providers. So is there any deficiency in service? How does it affect? What are the Bar Council of India professional conduct implications? Because that affects us. So there are some provisions of Advocates Act 1961 and BCI rules 1975 that affect us. So what are its implications on advocates? And this presentation will help you answer these questions. That is, I'm not going to answer these right now, but this is just to ignite your thinking. So we shall see what are the different types of questions that could arise. So we shall navigate through these emerging legal complexities in the Indian context. So this is just to provoke your thinking. And after this, we shall see what are the stakes in India for India. So why this matters for Indian legal professionals? Firstly, let us see the reality. What is the access? What is the penetration of internet in India? So Indian digital reality. There are 750 million approximately internet users, 75 crore. So world's largest online population. And you know already we are number one in Facebook and WhatsApp, the number of largest users in India. So because of our population and because of reach of electricity as well as the internet and telecommunication. Then we have digital economy. So we are using it for financial transactions. It's estimated as of 2023 to be 4.23 lakh crore digital economy. And all transactions we are making, even small transactions to say for taxi wala, rickshaw wala, sabji wala, doodh wala, and all these transactions we are, all people have QR codes. We are making all these online transactions also. So it is really a digital economy. Even for small sums like 10 rupees, 15 rupees, we are using mobile phones. It has, of course, security implications. 70% increase in cyber crimes. Now, because of this proliferation, that is rapid increase in the mobile phones and even digital devices, so cyber crimes are also increasing. So these are the 22-23 figures. Then there is average data breach cost in India, because it has cost all over India. Even in India, RBI and State Bank of India and many organizations release the statistics. So this cost is estimated to be 17.6 crores per annum. So these are the implications as far as our digital economy is concerned. And what is our role as what government of India calls as digital nagrik, that is digital citizens. So what are our responsibilities and obligations? We shall that also. As far as the legal landscape is concerned, some laws are already there. Information Technology Act 2000, we shall call it IT Act. IT doesn't mean here income tax. We shall be using it in the sense of Information Technology Act. India was the 9th country in the world when this act was there. Mainly it was to facilitate e-commerce, but now that is being reviewed. And the Digital India Act may repeal this Information Technology Act. So that is being drafted by the MeitY. So this is under review. Secondly, Digital Personal Data Protection Act, DPDP Act. It has been passed by the Parliament on 11th August 2023. President has given her assent to this, and the draft rules have been published in February 2025. The Data Protection Board of India has not yet been formed, and the date of notification is implementation is to be notified. So when it comes into effect, this law will be there. Justice B.N. Sri Krishna Committee had recommended that when it comes into effect, 2 years time shall be given for compliance. So maybe that may be given when this comes into effect to all the website to comply with the privacy. But even though we may not have dedicated law, the other countries have the law, and European GDPR, American, Canada, Singapore, Japan, all countries have their own privacy laws. So we shall see these also, how this Indian law is going to affect when it will be implemented. Then emerging liability under torts and contracts. So these two liabilities are there. So tortious liability, and we shall see there could be liability, and what are the principles that apply as far as the damages are concerned. So there are civil as well as criminal implications. Those we shall see. Both types of remedies are available. And then the professional that is there. So there could be some insurance claims that are rising, and when we transfer the risk to say insurers, so what are the professional indemnity principles that are there for the insurance companies in case of such cyber attacks? So that we have to see. Now the learning objectives. So today we shall see firstly the knowledge, that is what are the different existing Indian legal framework as far as AI cybersecurity is concerned. So we shall see the cybersecurity as well as how the AI, that is emergence of artificial intelligence, is going to affect that, or it is already affecting. Second, key statutory provisions and judicial precedents. We shall see some case law also. I have named some cases here. Then the liability theories under the Indian law, maybe tortuous, civil, criminal liabilities. Now the skills. So we shall see about the risk assessment for say Indian organizations, because security could be very costly if it is not taken care of. Prevention is better than cure. So we have to assess the risk and take risk management, risk assurance, insurance. So these have to be taken care of. What are the client counseling on AI cybersecurity compliance? As I told you, the even different websites will have to comply, because now it's not only cyber crimes, but there could be even individual privacy implications. And because of this privacy law, that is the DPDP Act, will apply to the digital personal data. So for that, there could be litigation. So that poses opportunities as well as challenges for the legal profession. And drafting the strategies for Indian regulatory say compliance, that is regulatory environment. So different types of regulators, what are the laws that apply to them, that we have to see. Then we shall see it from different perspectives. The first perspective is about India specific challenges and opportunities, which could be different from say other countries, that is European countries which have GDPR, America, Canada. They have their own privacy laws. International laws are also there, because internet there are say internet, we have extraterritorial jurisdiction of IPC or now BNS, even the IT Act and even the DPDP Act will have extraterritorial say application. Then comparative analysis with global best practices. So we shall compare this with what is happening elsewhere in the world on internet. Now we begin our 5 parts. So first part is AI as cyber defense. That is, we shall see the positive aspects of artificial intelligence, how it helps for cyber defense. Then we shall see the negative aspects in the second part. So legal implications under the Indian law. So we shall see that as far as the Indian say promise. So there are core capabilities in Indian context. Firstly, we have got CERT in. It is established under say 69A, 69B Information Technology Act. Computer Emergency Response Team of India. Legally, it is called as Indian Computer Emergency Response Team. It has all the wartime capabilities or wartime say powers functions. It can confiscate your say computers, laptops, mobile phones, all network equipment. During cyber attacks, it has all got all the it can stop your integrate say internet services. All these powers are there in the CERT-in as per the IT Act 2000. So it is our Indian Computer Emergency Response Team. 10 important industries have been identified that if there is an attack on them, like power grid, defense establishment, banking system, hospitals, major corporate houses, so it could lead to a situation like cyber war, and it has all the wartime powers. That is our CERT-in, which is a body established under the IT Act. So CERT-in has got these powers, and AI systems supporting national cyber coordination. So artificial intelligence can be there to detect or prevent, say, different types of cyber attacks. So that is an advantage. CERT-in can employ that. Secondly, our banking sector, it can use artificial intelligence. You already know transactions more than 50,000, different types of banking frauds, FEMA violations. So it can say income tax violations. So banking sector is there, and they have RBI mandated fraud detection systems. RBI has also implemented already in India, before the DPDP Act has been implemented, the concept of localization. That is, if it is financial transactions, the data must be processed within India. It can't be sent over the internet to other data processors. So we shall see that in DPDP Act. So that is there, and concept of localization, that is processing within country, or there are cross-border transfer restrictions that are there for financial data. Now it will apply to other data also after the DPDP Act 2023 comes into effect, maybe this year or next year. Then we have the government services. So government also provides different types of services. We have 4 e-commerce models, that is business to business, B2B, business to consumer, B2C, C2B, consumer to business, C2C, consumer to consumer, and fifth is G2C, that is government to citizen, that is e-governance we call it. Section 6 to 6 or 6 to 10 of IT Act. So government can provide all the services through the medium of internet, and these are valid like manual services. So government services, and because of that, there is digital Digital India security infrastructure. This infrastructure includes all types of system components, that is hardware, software, network, people, and procedures. So different types of government services are there. Then we have the corporate compliance, different regulatory authorities. Securities and Exchange Board of India, established under SEBI Act 1992. Insurance Regulatory and Development Authority of India, through which the insurance industry was privatized in India, that is IRDA Act of 1999. So these are the regulatory bodies it regulates the insurance industry. So regulatory compliances, or what are their requirements. Then the legal question that arises in such cases is that what will be in such cases the how to Indian laws govern AI systems, because there is no specific mention of artificial intelligence systems at present for the time being. So what police and prosecutors do, they book under the existing Indian laws. So AI systems and how these Indian laws will govern, that is making autonomous security decisions. Autonomous means on their own. So artificial intelligence can be used, or it can be deployed to detect some extraordinary behavior or attacks, and maybe it can be used for prevention, detection, as well as for recovery, that is after attack. Now, what is the Indian legal framework? We shall see in detail for AI defense key security provision. So information technology at 2000 is of course there. It will be reviewed. What are the existing say sections that affect? 43 is there. Different types of offenses are there: hacking, data theft, etc. Viruses. All these have been defined under various clauses of this. And there is civil liability. That is, there is adjudicating officer appointed under IT Act. They can award up to 5 crore compensation. More than 5 crore goes to your ordinary civil court or district court. Criminal liability is under 66. So for that criminal liability, section 66 is there. So the definitions have been given in 43, and there are civil as well as criminal remedies. Both are available under the IT Act. So section 43 is about, say, compensation for damage to computer systems. So damage is different from damages, as the lost ones might be knowing. Damage is injury. Injury could be of 3 types under IPC, that is injury to body, person, injury to property, sampatti, and third is injury to reputation, pratishtha ko hani. And damages is liquefied damages, that is a term that is used in torts to quantify that. Section 43A is there. It will be omitted now when the DPDP Act comes into force. It provides the compensation. Now there is no concept of compensation, because when such say right is given to large masses, that is crores of India, as we have seen in case of Right to Information Act, without any say locus standi, it gives to it opens the floodgates of litigation. Maybe advocates see that as an opportunity, but it has to be restricted. And so 43A will be omitted, and there will be only penalty. Penalty goes to the government exchequer. So you know the difference between penalty and compensation. Compensation is awarded to the victims. Penalty goes to the government exchequer. And penalty is civil, fine is criminal. So we are using these terms in different contexts. So this 43A, capital A, will be omitted now. Small a will remain. Those are clauses of section 43. 43A is a section. So there is, say, corporate liability for, say, in case of data protection. So if there is some, say, breach, or say if there is negligence, so criminal negligence could be there, or civil liability is there. So corporate liability for negligence in case of, say, data protection. Another section is 72A. So there is say disclosure, unauthorized disclosure, that is, it is violation of privacy. So disclosure of say potential information without consent, personal information. Consent is defined there now in DPDP Act. So when it comes into effect, there will be informed consent for what purpose the data is being collected, how much time it will be retained, and various rights have been given to Indian public called data principles in DPDP Act. So those provisions are there. Secondly, AI defense implications, how the AI is going to change this scenario. So there is reasonable security practices that will be mandated. These are mandatory. And say there are data fiduciaries, there are significant data fiduciaries that will be defined under the IT rules. For example, if you have got more than 5 crore people who are having account, large significant data fiduciaries like Google, Facebook, WhatsApp, Instagram, etc. So they will have to compulsorily mandatorily appoint data protection officer, just like under RTI Act we have the, say, public information officers. So the data protection officers or DPOs will have to be appointed when the Data Protection Board of India will be formed or notified by the government. Second one is Digital Personal Data Protection Act. Again, a very big act, 2023, it has already been passed. Some important provisions that affect security. Data security safeguards are there, prescribed in Section 8. Under Section 28, we have this penalty for data breach. Civil penalty is provided there up to 250 crores. It could even be increased up to 500 crores. And then AI defense benefit. So there is automated compliance monitoring. So that is significant advantage that we can employ or deploy AI, artificial intelligence, for monitoring compliance. So they will say monitor, they will also give the advice. As far as the Companies Act 2013 is there, So there is one important provision, and that is 134(3)(q). So cybersecurity disclosure requirements. That is what say measures you are taking for cybersecurity. Already we have section schedule 1 also under the IT Act. Schedule 2. So schedule 2 gives what are the cryptographic algorithms or the security mechanisms that are approved by the government of India. So central government has the powers and that notifies in section 2. It can even alter, add, delete the entries in schedule 2 of the IT Act. So they have to disclose under the Companies Act also. This provision is there. So these have to be displayed on their website, or what are the security disclosure requirements are there. Secondly, we have the board responsibility. So due diligence in AI security implementation. So the due diligence has to be ensured, and for that we as advocates have to advise our clients what are the due diligence measures that they have to do, so that they are always on right side of the law and never on the wrong side of the law, being law-abiding citizens. Now, Indian case law on cybersecurity, some significant judgments are there. So judicial precedents that are there, seeking, shaping the AI defense. The world artificial intelligence is now being recognized. And now, first is, of course, Shreya Singhal versus Union of India. You already know about this judgment, 2015. 66A was quashed. It was declared unconstitutional by the government of by the Supreme Court, that it is violative of 19(1)(a), freedom of speech and expression. Now this 66 capital A will be omitted. It has been omitted. It will be omitted when this DPDP Act comes into force. So 66A will be omitted. 43 capital A will also be omitted. So Supreme Court established proportionality, that is principle in cyber law. That is when you are posting offensive posts. Now crores of people are there, and they are posting so many things on internet. So what will be the implications when they are posting some offensive posts? So that can't be booked under 66 capital A, because that will be now omitted. So it establishes certain principles under this Shreya Singhal case. That is a landmark judgment. That is proportionality principle in cyber law. That is what will be the punishment, and what actually, because posting on cyber something on social media could even be offensive. There could be other sections that could apply, like defamation, or maybe hurting religious sentiments of someone, or like that. Other things could be there, inciting offenses. So there are reasonable restrictions as given in 19(2) of the Constitution. Now AI defense relevance is there. So automated blocking must be proportionate. That means you don't block, entire YouTube or entire Facebook. You just block the offensive pages within that. So that is already recognized by the government. So whenever they give certain blocking orders, it is there already under the IT Act. So when they block these things, so at that time, this could be done. So after Shreya Singhal, there is Justice K.S. Puttaswamy case versus Union of India, 2017. So on 24th August 2017, this came this Justice Puttaswamy judgment. It is a very landmark case. 9-judge bench, constitutional bench, and 7 judge, 1 judge, and 1 judge. Like there are 3 parts of that judgment. So it recognized right to privacy as a legal right, as a constitutional and fundamental right. It is not yet a legal right, but it recommended, Supreme Court recommended, that government should have some law, Parliament should enact a law for privacy, and therefore Justice B.N. Sri Krishna Committee was formed. It gave its recommendation, and now the DPDP Act has been drafted and it has been passed by the Parliament. So when it comes into effect, so privacy as fundamental right under Article 21. So this conflict between the right to information versus right to privacy, that is one fundamental right versus another, that is under 19(1)(a) versus 21. So this very good discussion is there within this judgment, a 9-judge judgment, which has 3 parts. There were 2, that is all the 9 judges have held that it is a fundamental as well as constitutional right under 21. That is right to live with dignity. And AI implication is that there is behavioral analytics must respect privacy boundaries. Now in artificial intelligence, when we are using other people's data, we are also using other people's personal information. Is it with their consent? What is the purpose for which we are collecting? How much data we are using? Is it proportional? So these things we have to see. And how long it will be, say, how long that data will be retained. So Reserve Bank of India versus Jayantilal and Mistry, RBI judgment of 2011, Bombay High Court. So it recognizes the corporate liability for inadequate cybersecurity. So that corporate liability is fixed. And secondly, AI defense standard, that is state of the art security measures have been are expected. So in case of artificial intelligence, how we can deploy it for defense purpose. So state of the art security measures are expected. That is ruled by the Bombay High Court in 2021. Now there are RBI guidelines on AI in banking. So let us see what are there, because there is Banking Regulation Act, RBI Act 1934, and RBI is a regulatory body for banks. So Reserve Bank of India AI framework is there. First, we have Master Direction on Information Technology Framework of 2023. That is mandatory AI governance framework has to be there by all banks. It also regulates the NBFC, that is non-banking finance companies. So fintech regulations are there. Board approved AI strategy is required. That is by the board of the bank. And risk assessment and audit requirements are there. So they have to assess the risk. They have to use AI for that, and even audit requirements. The key provisions that affect are firstly explainable AI. That means the artificial intelligence does not function as a black box. So explainable AI is we understand the logic how artificial intelligence is going to take certain decisions or how it is taking the decisions. That means it is not just input or output, but it explains what is the logic, what are the documents that it has referred, what is the basis on which it has arrived at a certain decision, and how it is giving the advice based on what. So it is called explainable AI. So explainable AI is the decision making transparency. That is, we understand how the artificial intelligence is working and what is the logic it is based on. Then the human oversight. That is, critical decisions require human approval. So there is human supervision. Oversight means supervision. So we are overseeing or we are supervising how the artificial intelligence is there. So when we are using artificial intelligence, you remember, already know that we have to do the manual proofreading, because nowadays just you give them the petition, it prepares your counter. You give them petition and counter, it prepares your rejoinder affidavit. So there are different ways, but sometimes it makes mistakes. These warnings are already there on ChatGPT, on Cloud AI, on Perplexity, whatever AI you are using, Gemini. So we have to see that there is, say, critical decisions are there, then it requires human approval. Data localization. I have already explained this concept. The data, if it is within the country, it must remain within the country. And data controllers, are they doing the data processing, or if they have some contracts? So second one is, say, after that is explainable AI and human oversight, there is data localization concept. That is, already RBI has implemented that financial data must remain within the country. As far as the other data is there, so that will also, it could be within country or it could be outside the country as per the DPDP Act and rules when it comes into force. So the government will, for different types of data, that is whether it is public, private, confidential, sensitive, secret, top secret, different types of data will be there, and that will be classified, and different types of rules may be there. So data localization concept is there. So AI is processing within Indian borders. This is called in international law as localization concept. So that concept is recognized within our DPDP Act 2023. Then incident reporting. Incident means security accident, security, that is breach of security, that we call as incident, for which we have CERT in India, that is Indian Computer Emergency Response Team. So it comes into play, it comes into action. So for that we have CERT say public say notification within 6 hours. That is, whenever there is security breach, immediately you have to notify your clients. For example, lakhs of passwords have been stolen or they have been hosted suddenly on internet. What happens to the clients? So immediately they have to inform. For example, suppose say passwords of a bank accounts have been disclosed, lakhs of passwords have been say, hosted on website. So immediately they will notify. They might even block your accounts, and there will be notification. Please change your password immediately because data breach has occurred. So compulsorily they have to notify their clients. so that there is no third party liabilities unnecessary. So just like in case of cyber crimes, we block our cards, ATM cards, debit cards. Just like that, there will be, in case of major security breaches, compulsorily these clients have to be notified. That is a requirement under the DPDP Act when it comes into force. Legal compliance. So we already have Banking Regulation Act 1949. Of course, RBI Act 1934 is there, which was amended by the IT Act 2000. There is another one, that is the Payment and Settlement Systems Act of 2007. And third is the FEMA, which has repealed the FERA 1973. So Foreign Exchange Management Act 1999. So that is our enforcement directorate comes under Finance Ministry. These are the RBI guidelines. Next, we see some other laws, that is SEBI, Securities and Exchange Board of India, because it regulates all the companies. And what is their AI regulation framework at present? So securities market AI governance is there. SEBI prohibition of insider trading regulations 2015 is there to prevent the insider trading, that is unfair practices. So AI systems monitoring insider trading. So AI systems can monitor whether these people had the insider knowledge or not, and maybe they can detect, maybe they can prevent also. Automated surveillance and alert systems. So surveillance and alerts will be there when something unusual activity happens. So that is SEBI regulations. Another one is SEBI investment advisors regulations 2013. So they can even advise the investment. So there are robo advisors. So robo advisors are there. The word is from robot, T is silent. So robo advisors are there. So they will, again, it's an application of AI, and robo advisors will advise the investors using the AI, using AI algorithms. Secondly, fiduciary duties in automated advice. So as far as the investment advisors are there, so these fiduciary duties have to be complied with in automated devices. So these regulations of SEBI of 2000, 2013, these apply. What are the legal requirements? So firstly, there is algorithm audit and validation. So what are the algorithms that are being used? Algorithm is a sequence of steps, the processes that are there. So these, what are the steps that are being there? So algorithm audit and validation is there. That is whether these algorithms are valid. Secondly, the risk disclosure to investors. So this must be there. This is to safeguard the interest of investors, general public. Thirdly, the professional indemnity assurance, insurance. So that will be there. That is, if there is risk coverage or insurance companies are involved. So what is the professional indemnity insurance that is there? Then we have compliance officer oversight. So there will be compliance officer who will oversee or supervise whether the SEBI regulations are being complied with or not. So these are the requirements of SEBI. Okay. Next we see part 2 of this presentation, that is AI as cyber threat. What are the disadvantages? What are how AI can be misused? What are the risks when we are using? Because even in say ITU, International Telecommunications Union, which is a body of United Nations, it has a series of webinars called AI for Good. Why for good? Because it is already recognized and acknowledged that AI can be used for bad purposes also. So how it poses threat? So there are now AI apps that change the photos, that there are videos that can be there. There are, say, fake things that can be, say, fabricated, artificial data that is being generated, text data can be generated, large language models, LLM are there. And there is much AI generated information. So here we shall see how AI adds a cyber threat and what is the Indian reality. So emerging threats in India are regional language deepfakes targeting elections. We already know the example of Kaun Banega Crorepati video that appeared. Who is the most corrupt chief minister in India? Choices A, B, C, D were given, and the correct answer was Shivraj Singh Chauhan of Madhya Pradesh. And then it came out that this was never happened. Amitabh Bachchan never asked this on KBC, and it was a deepfake video. Just because there are Vidhan Sabha elections approaching in Madhya Pradesh, and so there was this video against Mamaji, that is Shivraj Singh Chauhan, that appeared just to influence the elections adversely. So its role is already found, and even on Facebook, there are social media websites are also there. So it could affect the election outcome. Secondly, AI-powered UPI fraud schemes. Many such schemes are there. So whenever there is unified payment interface, UPI payment is there, and there are so many frauds that are there, and this could also be AI powered. So because the criminals or the perpetrators of crime also use artificial intelligence, and there is sort of race between law enforcers and lawbreakers. There are automated attacks on Aadhaar ecosystem. So automated attacks could be there. We already know about this, CAPTCHA we have to give, that is computer assisted program to tell computers and humans apart, because otherwise you can have denial of service attacks. That is, lakhs of spurious requests are there. Fixed frequency oscillators are used to generate, because they are operating in megahertz and gigahertz. So you can have 10 lakh or 100 crores requests per second, and that could slow your server. It can even crash your servers. So automated attacks like denial of service or even distributed denial of service, that is, they are from different IP addresses, could be there. Cross-border AI-enabled cyber espionage, it is already there. It could be backed by your countries. So the countries even encourage. So there could be cyber crime, cyber war, cyber terrorism, as well as cyber espionage. Cyber terrorism is punishable under Indian law 66F by life imprisonment under IT Act. Legal challenges that AI poses. Firstly, jurisdictional issues across Indian states. So whether we have got cross-border crimes, secondly, cross-border citizens, cross-border data, and extraterritorial application. So already our law is sufficient as far as this IPC, BNS, IT Act, and DPDP Act are there. So they all of these have extraterritorial application. But the problem is, do we have good relations with other countries? Do we have extradition treaties with them? So if these treaties or conventions are there internationally, then it is there. Otherwise, there are, we know greater cooperation among the criminals, but less cooperation among the countries, because they are at war with each other. And we already know the international scenario. Then international cooperation requirements are there. That is a legal challenge. Then evidence collection and preservation. So that is again a problem, because you can't go to a war against another country if they don't comply. Maybe you can have some sanctions. Maybe you can boycott them from trade, but you can't go to war. Maybe you can stop playing cricket with them. So implementation of international law is already a challenge, and that's why it is pseudo law, or we call it in international law as conflict of laws, because there is public international law as well as private international law. So it is very difficult to implement actually. And then we have attribution across digital boundaries. So there are technical as well as legal issues and jurisdictional issues. The CBI, Central Bureau of Investigation, represents the country of India in Interpol, that is the international police, which is a body of United Nations. So India is a member in that, and state police can't contact them, because as you know, there is nothing like Indian police. Police is a state subject, and we have police of states, Indian states. And as far though we have Union Home Ministry also, they also have some bodies like CRPF, many other paramilitary forces. But Central Bureau of Investigation represents the country of India. So that communication, international communication, must be through CBI, because some of those officers also duplicate as Interpol officers. AI-powered crimes under Indian law. So some important sections are there as far as this criminal law is there. So firstly, Indian Penal Code, 1860 provisions. Now, there are corresponding provisions within BNS also, Bharatiya Nyaya Sanhita 2023. So 378 theft, AI-enabled unauthorized access. How to define theft? We know this problem came in electricity also, whether electricity theft is a theft. So you could not book under 378, 379, 380, 381. And then Indian Electricity Act 1910 was repealed, and Electricity Act 2003 came. Data theft is now defined under 43 small, small ABC, data theft, hacking, etc. Different offenses are defined in 43 of IT Act. 420, cheating. So deepfake, fraud schemes are there. Now deepfake videos are there, but it's not defined. So traditionally the police is booking under 420, and for that you have to comply with 415. That is, there must be transfer of property. Then only you can book under 416, 417, 418, 419, 420. Next we have 465, forgery. So if there are deepfake, there are AI generated fake documents. So AI is there. Now there is how artificial intelligence can, how you can fix the responsibility. So these are the legal questions. So forgery could be there, and it could be done by artificial intelligence software. Defamation, 499, AI created false content is there. Now if AI has created, who is the author and what are the sources? So if you have explainable AI, maybe you can find out what are the reference sources. Under IT Act 2000, we have section 66, computer related offense. So whatever definitions are given in 43, those are punishable under 66. So there is, besides civil, there is criminal liability also. And for that there is Cyber Appellate Tribunal, which is now renamed in 2017 by Finance Act as Appellate Tribunal. And it is same as the TDSAT, that is Telecom Dispute Settlement Appellate Tribunal under the TRI Act of India, Telecom Regulatory Authority of India. So it is the common tribunal now, because the many tribunals were changed in the Finance Act, that is budget of 2017. Then we have 66C, identity theft using AI. So this identity theft, already this provision is there. Impersonation, assuming false identity, anonymous, pseudonymous communications. 66 capital D, that is cheating by personation. Deepfakes is there. So 66 capital D is there. Another section is 70, that is protected system access. Many say systems have been declared as protected systems under Indian law. That is electricity, defense installations, banks, hospitals, big corporate houses. So these are, that is, any attack on these amounts to say war against the country. And there could be, say, CERT that comes into picture, Computer Emergency Response Team of India, Indian CERT. So AI attacks on government. So AI can be used to attack the government. So that is, how do you book them? So proposed amendments are there, that is Digital India Act. So this IT Act will be soon repealed, and IT Act of 2000 will be replaced by this Digital India Act that is being drafted by MeitY. So AI specific provisions it will contain, it is hoped. The draft is not yet published by MeitY on its website. Deepfake criminalization proposals, that is the deepfake should be considered as a criminal offense. So let us see what happens when this Digital India Act is published. Now the case study. One important case study is of Karnataka Assembly elections. So deepfake video, Indian AI attack. So how AI can be misused? We shall see the example of this. The facts of the case are AI generated video of political candidate making inflammatory statements. Now, as you know, Election Commission of India monitors these activities. Circulated on WhatsApp 48 hours before voting, and 2.3 million views before detection and removal. Removal powers are also there to the government under IT Act. So legal proceedings are FIR under IPC sections 153 capital A 5052. IT Act section 66D charges were there. Election Commission model code of conduct violation was detected. Finally, the outcomes were rupees 50 lakh penalty was imposed, and new ECI say guidelines were issued by the Election Commission of India for AI generated content, and Supreme Court PIL on deepfake regulations is still pending. So this was something unprecedented that happened in 2024 Karnataka Assembly elections. And legal say lessons that we learn from these incidents is that what are the traditional criminal law? It is adequate because police have or prosecutors have to book it under whatever law is existing. But evidence collection, how you are doing that? So because now there is Bharatiya Sakshi Adhiniyam 2023, and it remains challenging because there are Part A, Part B requirement under the schedule to the Bharatiya Sakshi Adhiniyam that have to be complied. That the party as well as the computer forensic expert have to certify it. Cross-border crime, AI crime challenges are there. So internet jurisdictional issues are there. Mumbai police versus unknown case of 2023. Crypto AI fraud, cryptocurrency is there. People are investing. There are many cryptocurrency frauds. RBI doesn't recognize cryptocurrency. So AI system operated from Estonia, targeting Indian investors. Then there was say mutual legal assistance treaty, MLAI is invoked. That is whether we have MLAT with other countries. So if the treaties and conventions are there, you can, or extradition treaties are there, you can invoke these provisions in international law. Otherwise, it is very difficult to find the perpetrators. Then challenges AI extradition. Challenges are there in extradition as well as evidence sharing. Legal framework that we already have. So first we have Extradition Act of 1962. That is, say, limited cybercrime coverage is there. It's very old act. MLAT, that is Mutual Legal Assistance Treaty. We have with 37 countries at present. So varying cooperation levels are there. It depends on our international relations and mutual cooperation. CRPC section 188 is there. Territorial jurisdiction say limitations are there. Similar provisions are there in Bharatiya Nagrik Suraksha Sanhita BNSS 2023 also. Solutions that emerge here are firstly BRICS countries, that is Brazil, Russia, India, China, South Africa. So cybercrime cooperation framework is there. This is international scenario. Enhanced certain international partnerships are there, because these international agencies cooperate, like CBI cooperates with FBI, or our Indian Computer Emergency Response Team cooperates with other CERTs. Every country has its own CERT. Interpol, International Police. So Interpol red corner notices could be there for AI crimes. These are some legal challenges. As far as WhatsApp and social media liability is there, so platform responsibility for AI generated content is there. WhatsApp Limited Liability Company versus Union of India 2019. So in Delhi High Court judgment is there. Intermediary Liability Limitations Act, that is IT Act. What are the liabilities or intermediary? So we have guidelines under IT rules, as well as there will be some changes when the Digital India Act comes into force. And now there are certain provisions that are there in DPDP Act also. Safe harbor provisions for platforms, these are there. As far as AI content challenges are there, IT rules 2021 there is there. So due diligence requirements are there. While advising our clients, we have law students or lawyers, we have to comply with this and ensure compliance of our clients to this. Fact checking obligations for large platforms. So facts have to be checked before you publish them on your websites, or you host on your website as an intermediary. Or in case you get some complaints or grievance handling mechanism, in-house machinery should be there. So grievance redressal for AI generated harm. So whenever you already you know that Facebook, WhatsApp, and all these say big companies have their own say complaint or grievance handling mechanism, and they delete it within 24 hours, 48 hours, 72 hours. Legal standards are there. Section 79 of IT Act. So intermediary protection conditions are there, but there are proposed to be some changes in that in future. Then actual knowledge, that is when we talk of say vicarious liability. So AI detection system obligations, how do you detect whether it is manual or human generated? If it is image, is it by camera? Is it generated through software? How do you identify it? Then proactive monitoring, that is whenever such things appear. So balancing automation with privacy. So these are the challenges that are there in WhatsApp as well as social media liability. In part 3, now we see Indian regulatory landscape and compliance. So we see the India's evolving AI governance framework. What are the things that are forthcoming? So key regulatory bodies are there. MAIT is there, Ministry of Electronics and Information Technology. So AI policy oversight, so it supervises this. CERT-in, a body established under IT Act, Computer Emergency Response Team, so of India. So cybersecurity incident response. Incident is a breach, that is cyber attack. We call it as incident here. Sector regulators. So we have different. For banking sector, RBI. For companies, we have SEBI. For insurance, we have IRDI. For telecom companies, we have TRAI, Telecom Regulatory Authority of India. So different acts are there. Data Protection Board of India, that will be established under the DPDP Act when it comes into force. So that will be implemented. And just like information commissions, that is SICs or CICs, we shall have DP board for privacy rights in India when it becomes a legal right. And many different rights are being given to say 140 crore population of India. That is called as data principles in DPDP Act. So current status is there is National AI Mission has been launched 2023. AI ethics guidelines are under consultation. Then we have sectoral AI regulations are emerging in these different 4 sectors, and we have international cooperation frameworks that have been that are developing. As far as DPDP Act is concerned, let us see what are important provisions. India's comprehensive data protection law, it has not yet come into effect. Key provisions affecting AI cyber security, it has been passed by Parliament. Assent has been given by the President of India. Section 8 is data security safeguards, that is AI system requirements. There is section 16, data breach notification. So automated reporting systems should be there. 28, penalty up to rupees 250 crore. It can be even be enhanced up to 500 crore. So compliance automation benefits will be there. AI specific implications. Again, it is somewhat lacking, but some things can be extended to cover the AI also. So consent for processing. It should be informed consent. In case of minors, it will be given by their parents or guardians. So AI training data requirements, because the first the AI has to be trained and then it is tested. So this machine learning, deep learning models are there. 80-20 or 70-30% data is there that is used. Purpose limitation. For what purpose you are connecting the personal data from public? So purpose limitation is there, and it should be used for that purpose only. So AI system scope restrictions are there. Data minimization, that is you should collect only the data that is needed. So AI algorithm efficiency that will be there. These are mandatory. These mandates have been defined. Cross-border transfer, the concept of localization. So data localization for AI systems. Then compliance strategy. So that would cover firstly the privacy by design in AI architecture. That is, you are anonymizing or pseudonymizing data and re-anonymization or if you are identifying that is considered as an offense. That was there in the 2021 draft, but it has not appeared in 2023 Act that is finally passed, because there were 2-3 drafts that were published earlier in 2019-2021. Finally, another act has been passed, which is different from the Justice B.N. Sri Krishna Committee report. Privacy by design in AI architecture is there. Automated consent management systems could be used, and there is AI audit as well as accountability frameworks that could be deployed using the DPDP Act. Now, sectoral AI regulations. So industry-specific requirements are there. We are considering 4 important sectors here. Firstly, banking and financial services. So RBI. So there is master direction on IT framework for NBFC, non-banking finance companies of 2023. AI/ML, artificial intelligence, machine learning, governance requirements that are there. Model validation, that is AI model validation and audit mandates are there. As far as insurance sector is concerned, so we have Insurance Regulatory Development Authority of India, IRDAI. So outsourcing guidelines for AI services. There are also actuary is the person statistical risk measurement is done. That is called a actuary. That is a probability and statistics techniques are used. What is the risk? 2%, 3% in case of life insurance, marine insurance, fire insurance, different types of insurance. That person is called an actuary. So all entire insurance is based on that probability and statistics. So actuarial AI model approvals. Consumer protection in automated underwriting when we are insuring someone. Then telecommunications for TRAI is there, Telecom Regulatory Authority of India. So AI for network security as well as fraud detection, privacy protection in AI enabled services, and quality of service monitoring automation. So quality of service for multimedia data, that is text, picture, audio, video. And then securities market, SEBI guidelines are Act of 1992. So algorithmic trading regulations are there, because interest of investors have to be protected. AI powered investment advisory frameworks, then market surveillance automation requirement. This is there because large amount of transactions are being done every day. Now 13 guidelines, because that is our Indian Computer Emergency Response Team that is formed for incident response, that is in case of cyber war in India. So what are certain guidelines and compliance? So National Cybersecurity Coordination, so certain directions of 2022 have been issued. Mandatory reporting of cybersecurity incidents is there. Data breach notification within 6 hours. You have to inform your clients also under the DPDP Act when it comes into effect. KYC, know your customer. For cloud service providers and VPN services, virtual private network, that is when you are using public network and for private purpose within say large corporates. AI system integration, so automated incident protection. So certain feed integration is there. It has to be integrated with CERT, so there is automatic reporting. Threat intelligence sharing, that is AI powered analysis whenever some unusual activities appear on networks or servers. Response coordination, that is automated alert systems. So AI can be used there. Compliance requirements, so real-time monitoring and logging. Logging is we are monitoring all text files that are there for all the incidents that happen, whether they are successful or failures. So these are monitored in log files and they can be viewed by computer engineers and analyzed. So real-time monitoring and logging of all incidents. Incident response playbooks are there. Regular security audits and assessments can be done, and cross-border, cross-sector information sharing. That is, for example, banks are connected to income tax and like that. So cross-sector sharing should be there so that we can make our defense stronger. In part 4, now we see liability under Indian law and attribution issues. So liability framework at present is the core challenge is Indian tort law. It's not codified, as you know, based on British common law of first 400, 500 years based on Privy Council judgments. Contract law, 1872. And statutory provisions must adopt to AI autonomous decision making. And for that, there could be some changes that could be required. Maybe some codification, maybe some amendments, maybe some repealing. Key legal principles that are there. Firstly, vicarious liability, that is master-servant relationship with AI. If there is AI, if there is robo, if there are drones, who is controlling it? Secondly, strict liability, that is under the Rylands versus say Fletcher principle application. Law students must be aware of it when they study this in first and second semester. Professional negligence. So there is a Bolam test for AI deployment. What you are doing, can you identify whether it is done by human being, by say computers, and whether it is negligence, what is your direct involvement in that, it is without your knowledge or with your knowledge. Constitutional torts are there, that is the state liability for AI systems, because there are state sponsored espionage as well as cyber wars also. So what you do in such cases when governments are also involved. Now corporate liability theories. So first we have got this holding Indian organizations accountable. So there is negligence under tort law. So there is some cases I have named. We shall not go into say details of this, but Donoghue versus Stevenson principal application. Duty of care, that is whether there is due care and caution. It is defined under General say Clauses Act 1897, as well as it was there in IPC also. Now it is there in BNS Section 2. So what is the duty of care in AI system deployment? Have you taken due care and caution? Due diligence, what is also used in Western law. Standard of say reasonable AI practitioner. So what is reasonable? What is abnormal? Companies Act 2013 liability is there. So section 449 fixes officer liability for company defaults, board responsibility for AI governance, and due diligence defense requirements. As far as Consumer Protection Act 2019 is there. So deficiency in service, that is AI system failure. What is your liability when you are advising your clients and you are also using AI for advising or maybe for appearing before the courts? Unfair trade practices. So algorithmic bias is there, because this is a known disadvantage of artificial intelligence. Is it biased? Because it gives advice like that. If you say ask from say prosecution side, AI will advise you like that. If you ask from defense side, AI will ask you. So what is the prompt that you are giving to your AI? Consumer forum jurisdiction and remedies. What is the say consumer forums or consumer commission will do? What is their power under 2019 Act? So constitutional liability is there. Article 21, that is right to life and personal liberty. Privacy issues are there. State liability for AI surveillance systems, how you can fix that in case of espionage or cyber war, and proportionality and procedural safeguards. Now, insurance and risk management. So, managing AI cybersecurity risk in India. So, Indian insurance landscape. So, there is Insurance Regulatory Development Authority of India, Cybersecurity Guidelines of 2022. So, mandatory cyber insurance has to be there. General Insurance Council, cyber risk, say, pool initiatives are there. Lloyd's market, that is international coverage for Indian risks. Coverage considerations are there. Professional indemnity, that is errors in AI deployment, because many different things are coming. See, in case of insurance, because there will be autonomous vehicles, connected cars, driverless cars, these will come, and there will be accidents. These are legal issues. Who will be responsible? Is it car manufacturer? Is it software engineer? Because there are no drivers in such cars. So these are the issues that will emerge. There are drones, say Manav Rahit Yan. So who is responsible? So professional indemnity, that is errors in AI deployment. Public liability, third party say harm from AI decisions. Third party risk coverage or insurance is involved. Cyber insurance, that is AI specific exclusions and inclusions. That is when you draft these indemnity agreements or insurance agreements. Directors and officers, that is their board liability for AI governance, whether it is with their knowledge or without knowledge, how you can hold them vicariously liable or not, what is their civil or criminal liabilities. Regulatory requirements, these are by RBI, SEBI and UIDAI. So cyber insurance for banks above rupees 500 crore deposits. SEBI guidelines for mandatory cyber insurance for say market intermediaries, because intermediaries, what is their liability? There is some protection offered in IT Act, and sometimes they are held liable for hosting the contents that are there. IRDAI, so cyber insurance product standardization is there for Insurance Regulatory and Development Authority. Evidence and attribution challenges. So how do you collect the evidence? How do you prove it? Forensic considerations are there. So proving liability in Indian courts, evidence at 1872 provisions. Section 65 capital B is there, electronic evidence admissibility. Now there is 63 4A under Bharatiya Sakshya Adhiniyam 2023. Section 45 capital A, So expert opinion or digital evidence. Section 146, cross-examination on documents. AI specific challenges will be there. So algorithmic black box, because there is input, there is available AI. So explainability requirements will be there. Chain of custody, that is a list of persons who are there, who have that is from capturing it on say camera or recording up to the last stage, that is presentation before the courts. So who are the police, public, and say prosecutors who have held it under their custody, that is called chain of custody. That is integrity of data, because whenever there is allegation, so people say it is not my video, it is not doctored, it is fabricated, it is without my knowledge, and like that. So digital evidence preservation, that is a legal challenge. Expert testimony, that is AI system functioning proof. And then judicial developments. One important case is Arjun Pandit Rao Khotkar versus Kailash Kushan Rao Gorantyal of 2020 in Supreme Court. Electronic evidence validation requirements are there. State of Delhi versus Mohammad Afzal 2003 in Supreme Court. Scientific evidence acceptance standard, how we can accept the scientific evidence. It is affecting forensics, and now there is compulsory forensics under the Bharatiya Nagrik Suraksha Sanhita for 7 years and above offences, and there will be three say mobile forensic labs in every district. So as far as electronic evidence and specific evidence is there, these are the two leading cases. Professional conduct implications for us, that is for advocates. So Bar Council of India guidelines, BCI is there. Professional standards, Advocates Act 1961, professional misconduct definitions. BCI rules of 1975, competence and diligence requirements. Have you taken due diligence? Client confidentiality, because their interest. So AI system data processing concerns are there when you are using AI for that, because AI can do mistakes also. So what is our knowledge and experience doing at that time? AI specific considerations. So competence duty. So understanding the AI tools and their limitations, because what they can do, what they cannot do. Just like when computers came, we know their advantages and limitations. Supervision. So oversight of AI assisted say legal work. It should not be mere copy and paste. We have to read and say do corrections, because there could be some mistakes. Conflicts, that is AI system data sharing across clients. There could be conflict. There could be conflict of interest also. Fee arrangements, that is value billing for AI enabled services, because you could be outsourcing them if you don't know yourself. So how much you are paying, or maybe you are paying to your juniors as a law firm. Then emerging guidelines. Firstly, BCI, say, working group on legal technology. Secondly, State Bar Council AI ethics committees are there. And thirdly, continuing legal education requirements are there. So it could be lifelong learning for advocates. When we see part 5, so coming to this future legal implications for India, last part of this presentation. So what are the considerations? So looking at India's AI legal landscape, government initiatives are national AI mission, that is, say, rupees 10,371 crore investment is being done in national AI mission. India AI platform, that is central AI governance. From e-governance or mobile governance, we are now switching to central AI governance. AI for Bharat, that is research and development focus in under AI for Bharat. And then we have Digital India 2.0 coming. So AI integration across governance. So that is coming. And legal evolution, even responsible, say what are our responsibilities as a digital Nagrik that are fixed under DPDP Act 2023. Legal evolution is under Digital India Act, that is forthcoming. So bill will soon be say published. So comprehensive cyber law reforms are expected, which will repeal our IT Act 2000. AI ethics framework, that is multi-stakeholder approach will be there. Judicial AI, because now judiciary is also using, and they will be using. One Supreme Court judge has already warned that when you are quoting or citing AI, see that it is not minority judgment. Otherwise, there is a judgment, it is correct, but it is minority. So have you compared that with your actual judgment? Have you compared the provisions with the Bayer Act? So that cross-checking needs to be done by advocates particularly. So judicial AI, so court automation and case management. So for that, judgment, say judicial AI can be used. Maybe it would reduce our arrears also more than this 5 crore case judgment. So maybe we don't need judges in future, or there will be less role for judges, and we are using software to solve the cases. Give them the petitions of both sides, their counters, and maybe AI will deliver judgments. Can it happen? These are the questions. Legal education. So AI law curriculum integration. So this AI also has to be incorporated in the say law courses, LLB and LLM. Practical recommendations. So now see what are the action items for Indian legal professionals, for law firms, develop AI expertise within cyber law practice, update client service agreements for AI tools, create India-specific AI incident response protocols, and invest in legal technology training programs. For corporate councils, that is those who are advising the corporates, participate in company AI governance committees, review vendor contracts for Indian law compliance, because we have to see the due diligence requirements, assess the cyber insurance coverage for AI risks. Does it cover the cyber insurance? And then develop DPDP Act compliance frameworks, because it will be implemented. Maybe the government will give 2 years, maybe it will give less time. What is our preparation when the DPDP Act will be notified by the government? It could happen any day. Then for government lawyers, that is prosecutors as well as those brief holders or say other attorneys, advocate generals, what are the implications? So understand AI implications in regulatory drafting. Secondly, participate in interministerial AI policy development. Thirdly, develop AI procurement guidelines for government, because they will be procuring AI also, hardware, software, network. Create public-private partnership PPP frameworks. So that is for government lawyers. So these is say practical recommendations for law firms, for corporate counsel, as well as for government lawyers. Now, what are the questions for discussion? I am giving 3 scenarios here. Firstly, say for example, Chennai-based IT company's AI security system blocks employee access during a critical client presentation. Suddenly, because of the cyber threat or to protect the system, the client cancels rupees say 10 crore contract. What are the liability implications under Indian contract law and tort principles? Is our legal framework adequate? What are the existing laws? What amendments are needed? Second scenario, Delhi High Court advocate uses AI to analyze opposing counsel's case strategy, because it is very easy, as I told you, just give them opponents say, or you have to prepare or challenge some court judgment, simply upload it and it will challenge, it will prepare you petitions for the next court. You specify your country location, give them facts, give them scenario, give them your factual metrics of the case, and it will prepare. Already lawyers are using it. So inadvertently accessing confidential client information. So what professional conduct issues arise under the BCI rules? Because we have to maintain the privacy, we have to maintain confidentiality. There are provisions under BCI rules, there are provisions under Indian say protection that is given under Indian Evidence Act, or maybe in Bharatiya Sakshi Adhiniyam. An AI generated say deepfake video of a Bollywood celebrity is used for cryptocurrency fraud, and it is being misused. Okay, targeting NRI investors. How do you address jurisdiction and enforcement challenges? Already we know the case of Amitabh Bachchan, who had to go to Bombay High Court because there was KBC audio that was in his voice, and he told that it is my privacy rights and my voice is being misused for committing crimes. And then government, this Delhi High Court had to uphold that privacy is a right and voice is important biometric. So that is huge physiological characteristic, and therefore he has privacy right, and voice can't be misused for perpetrating crimes in the name of celebrities. Some resources I am naming for further learning. So to continue our cyber security legal journey, professional bodies are there, Bar Council of India. So there are different legal technology committees are there. Indian Society of Artificial Intelligence and Law is there. Cyber Law Association of India is there. Key publications are there, Supreme Court cases. So AI and technology sections are there for those who are already subscribing it. All India Reporter AIR for Supreme Court as well as High Court laws. So cyber law reports are published. And then we have NALSAR, say law review or National Legal Services Authority. So they have published these technology law articles. We can also refer to training opportunities. So for that, National Law School Bangalore, NLSIU, already they have AI and law certification. So maybe certificates and diploma courses can be done. Then say Indian Law Institute, ILI. So cybersecurity law programs are there. Then we have NLSIU centers for public policy. So AI governance courses are there. As far as government is concerned, so government resources are there. You can refer to METI website, Ministry of Electronics and Information Technology. AI policy documents are there. Certain Computer Emergency Response Team, they have their own website. Cyber security guidelines and alerts are there. Law Commission of India, LCI website. You can refer to that. Technology law reports, more than 200 250 reports are already there. Key takeaways for Indian practice. So remember, what are the important principles? Firstly, Indian legal system adaptation. So traditional Indian legal principles are evolving to address AI challenges, stay current with the judicial developments. Secondly, regulatory compliance priority to be on right side of the law. So multiple sectoral regulations create complex compliance say landscape, and that poses challenges for us as lawyers and advocates. So develop integrated approach, a constitutional foundation. So right to privacy under Article 21 and due process principles guide AI regulations, because AI will be legal right also. At present, it is just constitutional and fundamental right. But now it is going to become legal rights, because Data Protection Board of India will be there, and there will be no need to go to High Court and Supreme Court for this legal right. You can only go in appellate jurisdiction there. So understand fundamental rights implications. Then cross-border complexity. So India's digital economy requires international cooperation. So build global perspective, because enforcement of international law is already there, and internet has cross-border complexity. Then professional say responsibility evolution. What is our responsibility as professionals, or as a legal professionals, or maybe other professionals? So legal profession must adopt, that is to AI tools while maintaining digital standards. So we have to comply with digital standards as are specified in IT Act, as well as other compliance requirements, and invest in continuous learning, because otherwise we will become obsolete. So we can conclude the Indian path forward is firstly the reality. AI cybersecurity is transforming India's digital landscape faster than, say, legal frameworks can adopt. Secondly, the opportunity. There is opportunity as well as threat. India legal professionals have the say chance to shape progressive AI governance while protecting fundamental rights. Even those who are to do freelancing or practice international law, so it a great opportunity for lawyers. Responsibility. So we must ensure India's AI development remains ethical, secure, and legally compliant. That is our international obligation also. And the vision is, say, Vasudhaiva Kutumbakam, that is the entire world as one single family, as our Indian philosophy is there. So India leads critical, say, global AI deployment, development. Our say legal frameworks must be compliant. That is, they must balance the innovation with justice. That is our responsibility as a country. So, lastly, thank you. Dhanyavad. Thank you for your attention and engagement. Additional resources that we can refer to are Government of India AI portal, ai.gov.in. Certain alerts you can get from cert-in.org.in, Indian Computer Emergency Response Team. Indian Cyber Law resources you can access from cyberlaw.org.in. So next steps are develop download the presentation material. I'll be sharing my presentation with the hosts, and they will share with you, or you can send me email and I will send the copy of presentation to you. It will be hopefully uploaded on YouTube also. Join Indian AI and cybersecurity law discussion groups that we can do as law students or lawyers, and schedule follow-up consultations for specific compliance needs. And lastly, we can say that भारत में AI और साइबर सुरक्षा कानून का संगम एक नया युग है, because it's a new generation and it is revolutionizing, and जहाँ परंपरा और तकनीक मिलकर हमारा मार्ग प्रशस्त करते हैं. So it is a threat, it is an opportunity also. So I'll end my presentation here, and let me see if there are any questions.
Thank you so much, sir, for such great knowledge. Participants, in case you all have any queries, use the raise hand function, or write down your queries in the chat box. Let's be quick. Sir, can you explain the concept of cyber insurance, because never
Yes.
heard of it?
So cyber insurance, just like any insurance, it assesses cyber risks. That is, in case of cyber breach or some loss occurs. So there are indemnifiers, there are insurance companies, because see, it doesn't happen every time. There is actuarial science that is involved. For example, as computer engineers say, we take the backup and restore. We know 99% backup is never used. But what happens if you lose your database? So then only the backup can be restored, and from that you can get all your data back. Now there is, say, this recovery measure. That is a technical measure. The legal measure is you pass on the risk to some other person. So what did the actuaries do? In case of life insurance, fire insurance, marine insurance, suppose there are 100 people, 97 people are alive, 2 or 3% people die, and they will be the claimants. So we collect premium from every person, and then we compensate or we give the claims to those who are say actually the victims or against whom some loss has happened. Same thing happens in marine insurance or say fire insurance. What happens in cyber attacks? In case of cyber attacks, if there is an attack, so what is the value of that data to you? How important is it to you? Is it public data? Is it private? Is it secret? Is it top secret? Is it classified? Is it confidential? Is it personal? It is say personally sensitive data. Based on that, you can classify and you can have this hold the insurance say liabilities insurance companies that will provide you the cover, and they will cover your insurance that in case of cyber breach or if this worst case happens, then we shall say indemnify you, we shall pay you so much sum. So these types of agreements could be there with the insurers, so that way we can transfer the risk to them. And then there are general usual clauses, as we know, like act of god, like happened in case of corona covid. So if there is war, flood, earthquakes, because this could happen even to data centers, and there could be cyber attacks also. So there could be physical attacks, there could be attacks on say software systems, hardware. There could be insider attacks also. So people inside or outside the organizations may attack. So what is your preparation in case that happens? Because cyber security is many times it is an afterthought. That is, people don't realize the value unless there is an attack. So we have to realize that prevention is better than cure. And what happens if the worst case alternative happens? So we have to prepare for that. I always tell my students that you should be such a computer engineer कि आप मरो तो भी फिर से जिंदा हो जाओ. What is the meaning of this? How you can be alive after you die? That is, what is your backup? What is your restore? So if something happens to your data or your information that is critical, how important is that to you? So imagine all the bad things that happen, that could happen. Imagine the worst case scenarios, because security is a mindset. It is just like happiness. If you think you are happy, you are. If you think you are unhappy, you are unhappy. While in case of cyber security, you have to think all the bad things that could happen to you. So I always train my student like this. सब बुरी बुरी बातें सोचो. ये मत सोचो कि अच्छे लोगों के साथ सब कुछ अच्छा होता है. अच्छे लोगों के साथ भी बुरा हो सकता है. So what is your level of preparedness when the breach happens? So if you think from that viewpoint, that is what makes you a strong, your security strong. See, even in legal arguments, we do it as lawyers. We always think from opponent's viewpoint. अगला क्या सवाल पूछ सकता है? What is their defense? How we are going to counter the question that could be say asked by the opponent lawyer or by the judges? What is our preparedness? And according to that, we prepare our cases. So similar to that, we have to prepare for these types of issues. Thank you.
Okay, sir.
Good afternoon, sir. Had a wonderful lecture and a lot of insights for the lecture. So thank you so much for enriching us. So there are two questions of mine. So one is that there was a cyber fraud and I have procured the court orders and I have given it to the cyber department and they have also forwarded to the Bank of Maharashtra. But still the defreezing of the amount is not being done, sir. So in this case, and the order was taken in the month of March and now we are in August. So sir, so long they have not been enacting on those. So what is the next step I should be doing for the same?
Normally, they don't freeze the entire account. What they do is there is lien, that is कितने का fraud हुआ है. So based on that amount, that minimum balance must be held in that account, and above that the transactions can go on. So there need not be necessarily entire freezing the account, but the lien account must be held under lien. And while the investigators are doing this, now if there is already court order and if they are not complying, then that could be a matter of contempt. So maybe you can file
Yes, sir.
contempt. Maybe you can issue a letter that this must be preserved, so that there is preservation of evidence. And because there could be some automated deletions also, like in case of say CCTV records and some other things. So whenever you're doing, you must also raise an alert that you have to preserve this thing, because this is sub judice, this is under honorable court's consideration, and then they have to comply with that. Otherwise, if they destroy the evidence or some other things happen, then you can hold them liable under maybe say IPC 204 or destruction of evidence, because this is actually an offense against public justice. So these type of provisions are there. So these are some alternatives before you.
Okay,
Next
sir,
question, please.
thank you. Sir, the question was, sir, in these kinds of frauds, when there is a cyber fraud, So is bank responsible? Can bank give us the money in case, because we keep the money in the bank, ensuring that it's safe in the bank. Now these things are happening even if we are not giving the OTP or passwords. Sometimes they are being deducted from our bank account. So isn't the bank held reliable for these kinds of the transactions which are being done?
Of course, banks are liable. See, if you see the RBI regulatory framework, so in many cases, the banks have to pay the clients. So what is, they see the facts and circumstances of the case. When did you report the crime? So suppose there is ATM fraud, did you report within say 24 or 48 or 72 hours as per your bank's requirement? When did you go to file the FIR? Have you blocked your cards? Did you reveal your OTP yourself? Because there are some frauds like spoofing attack, social engineering. That is, they are making phone call and the person himself or herself is revealing his or her password. So in such cases, what is the liability of the bank? They can't be held accountable. So it depends on facts and circumstances of the case. But if you have taken all the precautions, you have blocked the card, and if there is transfer, sometimes we are using third-party payments also, like say Paytm, Google Pay, and now account is deducted from our say account. And if the transaction has failed, now there is a concept of atomicity in transaction, that is either it is done or it is not done. So if there is some problem due to say client end, server end, or maybe network failure, so the transaction must be reverted. That is, the amount that was debited is automatically credited. Now, if it is not credited automatically, then there should be transparency. For example, if account has been deducted from my account, where did it go? So banks should disclose that because they have transferred. So they can't say that State Bank of India, for example, can't say that it has gone to Paytm and we don't know to whose account it has gone. So who are the beneficiary? So that must be there. And these are our rights as a consumer also. So they that must be there, that if the account has been debited, definitely it has been credited to some account. So who is the beneficiary of that? So while they are doing the investigation, sometimes they don't reveal because it may hamper the investigation. Other persons might get alerted. Sometimes the amount might have already been withdrawn, but at least there should be some things that could be traced. And for that, the compliance authority, we normally have 1930 helpline. We also have cybercrime.gov.in. So immediately you must say report to them. They will send you OTP. They find out your email address. You have to upload your Aadhaar card, and immediately you can take the technical or legal help from them, and they have to do that. So RBI fixes the responsibility. If your banks don't comply, then maybe you can lodge a complaint with the Reserve Bank of India, and they can force the bank to say compensate or to credit the amount to the customer's account. So sometimes the banks or even the private banks or even they could be non-banking finance companies, so they don't comply. At that time, you can take the help of regulatory bodies. So that alternative is available to you. Thank you.
Yes, sir. So is the time limit when we file the FIR or when we register a complaint, is there a time limit like in 24 hours, 48 hours? Because normally these things happens on weekends and Saturdays and Sundays being non-working Saturdays or Sundays, then Monday the time duration has lapsed like it's more than 72 hours. So is that also a criteria, sir, for or
Yes, definitely, definitely. See, just like when you lodge the FIR, are you lodging the FIR? You have to explain the delay. Is it immediate? Or say, is somebody lodging the FIR after few months or few years? So it becomes your case if there is too much inexplainable delay. Similarly, in case of cyber frauds, one interesting trend has been observed that normally they happen on Friday. Why
yes,
Friday?
sir.
Because banks are closed on weekends, but still some systems are working. Like ATM is there, 24-hour helpline is there. So systems are working 24/7 by 365. Net banking, other things are there. You could block the access. So the blocking can be done immediately. So these things are there. Call centers, data centers, these are working round the clock, 24 hours. So nowadays, it doesn't make much difference. If you see the new law, so under the new law, see, there could be limitations, but normally it is only in ATM cases that you have to do in 24 hours, 48 hours, 72 hours. Why? Because they preserve the data for reasons of privacy only for 7 days. Otherwise, there is automatic overwriting or say deletion of previous data because it's not necessary. It could violate privacy. So unless there is cyber fraud or something that is reported adverse, then only in that case they would preserve the data. So that must be done within that limit. Secondly, if you see the BNSS provision, Bharatiya Nagrik Suraksha Sanhita, now there is a provision of e-FIR, as you know. So electronic
Yes, sir.
FIR. So you can lodge electronic FIR, maybe from your mobile phone. Any victim can do that. And then you have to confirm it by going to the police station within 72 hours. So you can then go to the police station personally and then lodge an FIR. So for that 72 hours time is given, and that is sufficient. So this provision of e-FIR is there. And if there is some reasons beyond your control, there could be delays in some cases, but then you have to you are responsible to explain that delay. It should not be like in case of say these these cases I found that there is live-in relationship and they are living together for 2 years and then they are lodging under 376. So these things should not be there. That is, there should be reasonable
Correct, sir.
delay. What would a person do when that person is kidnapped or abducted or raped? Immediately they go to the police station. It can't be suddenly that they are awaking after 5 years, 7 years. So and so things happen. Me too, me
Yes, sir.
too. So that doesn't help.
Correct.
So
Yes, yes,
the
sir. Sure.
delay must be explained. Otherwise, it becomes the case.
Yes, sir. Thank you
Yes.
so much, sir.
Sir, what are the best methods to protect personal storage devices like one TBSD card or a tab from cyber attacks or unauthorized access?
Yes. For that, see, some traditional mechanisms are already there. Firstly, physical security. There should not be any water or liquid that falls maybe on your keyboard or other devices, hard disk, etc. Secondly, it should be dust-free environment. Maybe earlier there were temperature requirement, but now they are temperature resistance. They survive very old or say new. Secondly, password. So password is not only system level. You can have password in your hard disk, etc. You can have file level password. Like say when we have question papers, etc. Maybe we have file level password so that the question paper doesn't get leaked. So when you are holding say secondary data on your secondary storage device, whether your hard disk is magnetic, optical or semiconductor device, so on that you can have the data encrypted. So if it is encrypted, then in such cases you won't have say even the other people if they get hold of your data, they will not be able to understand anything. But you must remember your own key. If you don't remember the encryption key or decryption key, then the data is lost from you also. Nowadays there are ransomware attacks. Ransomware attacks like they ask you for ransom, firauti. They encrypt the data on your hard disk, and for releasing you have to deposit so and so amount in my account. So like that, the ransomware attacks are also there. So these types of sophisticated attacks are there, and therefore we have to safeguard our personal data also, and regular backups. It is very important. Just like we say regular steps to clean our body, we take bath every day. Similarly, there should be backup schedule. That is whether you are taking the backup every day. What is your weekly backup schedule, yearly backup schedule, annual backup schedule? So when particularly when we are in charge of other people data or we are acting as custodians of data, so at that time we have to take these precautions in case of all the data or entire computer networks or hundreds of thousands of computers could be there, because these are nowadays stored on clouds. So what are these clouds? These are actually data centers, and they are earthquake proof, they are waterproof, and then if there could be electricity failure, there could be power failure. So what is your preparedness in case of such attacks? So these types of precautions has to be there, and therefore one has to be say aware of security. That's why I say that security is a state of mind. So we have to imagine and imagine all the bad things that could happen, and then according to that we have to prepare for cyber security, because it is actually our level of preparedness. Thank you.
So can AI generated cybersecurity reports be admissible as
Yes,
evidence
of
in the
course.
court?
Yes, AI generated could be there, but AI has got some more say firstly when you are giving it to courts, you may you have to acknowledge that it is AI generated. We also generally allow AI to our students also. We are ourselves using it for our teaching and other material generation. When you are say there are intellectual property rights, because there could be piracy, there could be plagiarism, academic integrity considerations are there, and there is too much say text generation by AI also. It is not only text, it is also images, it is also deep fated, and therefore it is posing challenges day by day. And that's why this AI for Good or International Telecommunications Union, ITU, they are making the public aware for this, because there could be say many issues that are posed, because there are drones, there are autonomous vehicles, there are connected cars, driverless cars, there are robots. In Robo movie, we have seen the Rajnikant even raises the entire army, even falls in love with Aishwarya Rai. Are these things going to happen really? So these are some of the interesting questions that are there. So AI, it is a challenge, it is a threat, it is also an opportunity. So it can be used for defense purpose, and we have to harness the AI so that we can use it to complement our job. See, it cannot replace the human beings, but a person who knows AI can replace another person who doesn't know AI, and therefore we have to be AI conscious also. Maybe we can have some special episode on prompt generation, that is how to use artificial intelligence for as a complementing in our work, and how to intelligently use that, because there are these issues that could be there. Even the courts, because we are using, advocates are already using it for pleading generation, but manual supervision oversight is very much necessary, because you can't blame it to AI. AI has generated this and therefore I'm not, because see, advocates are signing all the pleadings, clients are signing affidavits, and so they can't say feign ignorance that we are not aware it is machine generated, because although it is machine generated, but we as human beings are ultimately in control. So we have to do that in case of all these challenging questions. Thank you.
Sir, in the event of a mistake or omission, can an advocate take legal action against the app developers?
Yes, that is there, because there are, as you know, see, the level of awareness is very less. There is the EULA, end user license agreement. But what we do when installing software, next, 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 and click, 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 software is automatically installed. Now, if you read that entire end user license agreement, it is just like a disclaimer. We are not responsible for this. We are not responsible for that. And ultimately, you are facing a question. If the software is not responsible for anything, what I am doing to my computer? So you might get afraid and stop the installation or leave that app altogether. But these types of disclaimers are there by software developers. So whenever there are agreements, so at that time, these are actually the drafting challenges even for lawyers, because whenever there are say corporate agreements or they are drafting, so these things have to be specified. Who will be responsible if this and this happens? So this liability, civil or criminal, has to be fixed. And that's why these are the challenges, and these things are going to be there. See, now there are drones, there are going to be, say, driverless vehicles, and these are actually the issues. See, technology is not an issue, but what are the things, what are the problems that it is going to create? We must be aware of that before taking advantage of technology, because just like all the tools, it can be used, misused, and abused. And for what purpose we are going to do that? If there is, say, a knife, it can be used for committing murders, it can be used for cutting vegetables, it can be, the doctor uses it as a scalpel for saving the lives of people. So just it is another tool. AI is also another tool. And just like computers came, there were apprehensions. So when the AI has come, there are so many apprehensions, so many questions, but we have to use it intelligently and aware of all the things, and we have to do the SWOT analysis, strengths, weaknesses, opportunities, and threats that are there. And if we do that, then we can use AI fruitfully in our work to complement our work and to automate the things. Thank you.
So how do courts verify the authenticity of AI generated cybersecurity reports?
It is very difficult. As per, because there is no difference, there are different models are there. What actually is being done, I'll tell you from plagiarism example. The AI itself can be used to detect the content that is AI generated and human generated. Now, if the codes, because if they are not using AI, so without the help of AI, for human beings, it is very difficult to find out who is at the other end. It is called as the Turing test. There is computer scientist Alan Turing, and Turing has given a Turing test. That is, can you as a human being identify who is at the other end? Is it a human being or is it a computer? And we already know there are CAPTCHA, computer assisted Turing test programs for telling computers and human apart. So there is a scramble test, and now there are image processing software also. So is it automatically generated? So if you are human being, you are less harmful, and you have to prove again and again that you are harmful by typing that CAPTCHA text that is there on website. It is a security measure. Otherwise, there could be automated. And if you are a software, then you could be very dangerous. You could launch denial of service attack. So are you going to say, slow down my server and crash it? So these are the considerations. It is very difficult actually. So AI can be used to detect, even in case of digital image processing, we are using say software, and there is metadata that is associated. Is that picture software generated? Is it camera generated? And if you have say GPS system, then maybe you have the longitude, latitude, and altitude when that picture was taken, where it was taken, and there is year, month, date, time in hours, minutes, seconds. So that is there. But if it is not there, then you don't know by whom the picture was taken. Similar are there issues that are related to privacy. There was case of this WhatsApp in Indian Supreme Court. Who has forwarded and then there were restrictions that you can't forward to more than 5 groups. They say mark it as say forwarded. They mark it as many times forwarded, frequently forwarded. But if you are doing copying and editing and pasting, then there could be many data originators. So from where did actually that message originate, and how do you fix the responsibility? So these are some legal questions that arise in such cases. And then WhatsApp told the Supreme Court that, see, we can't do the authentic identification of sources every time. And there are even international issues. See, they are operating in international environment, although they have Indian offices and more than 50% users are Indian. So what are the privacy implications when they are working in an international scenario? They are even protecting the privacy. So under the garb of surveillance, are you violating the rights of your citizens to privacy? These are some interesting questions that arise. So to what extent the government can surveil its citizens? It is necessary in case of cyber war, in some cases. So cyber espionage, but is it legal? Is it ethical? These are some questions that arise when such types of complicated problems arise. So at individual level, at country level, at international level, we have to say view it from different dimensions. Then only these questions can be answered. Thank you.
So, sir, we are done with the queries. Can we wrap up?
Thank you. Yes, please. Yes.
So, sir, thank you so much for such an illuminating talk. It was a very new topic for us, and we really got to learn so much from this. Thank you so much, sir.
Thank you.